So far.
Had a little illness last week,
Fine.
right? One of those bad.
Okay, good morning, everybody. The time being 9 a.m., I'd like to call today's Judicial and Public Safety Committee to order. My name is Myrna Molina. I'll be chairing today, Thursday, October 13th meeting. May I please have roll call?
Brown,
Brown here.
Gums,
Gums here.
Leonard,
Leonard here.
Sanchez,
Sanchez present.
Shepro, Davis, Molina.
Molina
We have a
present.
quorum.
The next item on the agenda is approval of minutes. We are approving minutes from August 11th and September 15th, 2022. May I have a motion and a second?
I move for unanimous consent of the minutes.
Okay, we have unanimous consent for minutes. Next item on our agenda is public comment. I had one speaker signed up to speak, Matt Lyson. I think Mr. Lyson spoke at last month's meeting, but I don't see him here, so there might have been an error. So we will move on. Our financial reports are on file. Do we have anybody here from the Merit Commission? Okay, otherwise, the Merit Commission report is on file. And we will move on to KCOM. Ms. Guthrie, good morning.
Good morning. Our monthly reports are on file. We had an extremely busy September. A lot of the projects that we've talked about for even a number of years have gone live. We did a quick upgrade of our phone system, 2 weeks of testing on next generation 911, and then we went live. As you can recall, next generation 911 replaces our antiquated, analog based phone system. And it is state mandated. So eventually every 911 center within Illinois will be on next gen 911. This better allows, more appropriate routing of our cellular calls, less transfers between our centers. So it's something we've been working on with our neighboring centers for a number of years. And now we are one of the first 20 agencies in Illinois to go live. So we are excited for that. In addition, I would have loved if Sarah, our deputy director, and our operations manager, Chris, were here, but they are at another meeting. I have a huge thank you to them for all their support through the Live Golf event. So we went out for 4 days, Thursday through Sunday. They handle public safety communications from OEM's Command 1 on site the entire day. The event went very well, but it did take a lot of support from our team, both in the comm center and on site. So they were there handling that. And we do continue to hire, so that posting remains active online. And a number of, community outreach things such as talking in high schools, going to hiring fairs, anything that we can do to increase our applications. And that is all I have this morning.
Thank you. Any comments or questions for our KCOM director? Okay, thank you, Ms. Guthrie, for being here. Okay, we will move on to our sheriff. Sheriff Payne, good morning.
Morning, everybody. Just to cap off on what Ms. Guthrie said, we successfully pulled off the Live Golf event with no major issues. We had to remove a few intoxicated folks, one at like 10 in the morning. So, wow, he got ready early. So, no, just big kudos to our team and her team. It went very, very smooth. I do want to move on to the resolution, and then kind of unorthodox, I want to show a video at the end of that I'll introduce, very short video. So if we want to move to that, that'd be great.
Okay, yeah, let's go ahead and make a motion and to introduce, discuss, and potentially approve the resolution.
Leonard so moves.
Brown seconds.
Around seconds. Okay, Sheriff, you want to go ahead and introduce it and
Sure. This is just an update to our intergovernmental agreement between the Central Community School District for our school resource officer and the Kane County Sheriff's Office.
okay, any comments or questions? Do you want to do the video first?
Want to vote on this one and then we'll do that?
Oh, sorry, videos after
It's
this.
unrelated.
Okay. Any comments or questions regarding this resolution? Okay, may I please have roll call?
Brown,
Brown, yes.
Gums,
Gums, yes.
Leonard,
Leonard, yes.
Sanchez,
Sanchez, yes.
Davis,
Davis, yes.
Molina.
Molina, yes. Okay, so this passes on to our executive committee. And Sheriff Payne, go ahead with your video.
Thank you very much. So technically, this judicial and public safety is not my last of my first term as sheriff. Next month will be my last as first term as sheriff. But I just wanted to reflect on the last 4 years that we've gone through together. It's been unprecedented, as we all know, from COVID to civil unrest to bringing the sheriff's office leap years from where we were in 2018 until now. And you guys really were the foundation to all of that. So this is just kind of a reflective video and a thank you to the county board and judicial public safety. Thank you all.
Thank you, Sheriff Payne. Any comments or questions regarding the report in the video? No? Okay, we will move on.
Thank you. The biggest update that we have at the state's attorney's office right now is that we have been in active negotiations with two other state's attorney's office and the sponsors of the House Bill Safety Act. We have been doing a significant amount of work. Today is day 4 in terms of those negotiations. I can say that I feel very positive about the changes that are being proposed and received. I think that everybody who's coming to the table has the best of intentions to do the elimination of cash bail, but to do so not only protecting the rights of the accused, but the safety of the victims. If anybody would like details about more of what we're discussing, the proposed changes, timelines, things like that, I would be more than happy to discuss with them. When I'm done talking here, I'm running back to the office for part 4 in this discussion portion of it. But I can say that between ourselves, DuPage County and Champaign County, we're doing a significant amount of work to make some litigation that had the best of it, or legislation that has the best of intentions better. So again, if you have any questions, please let me know. Otherwise, I do believe we have 3 resolutions.
Can I just?
No video?
No.
Next time.
I
Um,
want to just
Sheriff
point out
Payne, yes, go
that
ahead.
State's Attorney Mosser has become a statewide leader in changes for the Safety Act and getting us where we want to be on all sides. And I just couldn't be more proud of what she's done on our behalf. So thank you.
Thank you.
Yes.
I will put that in a video for next month.
Wide leader.
Thank you. A lot of us caught you on TV a few days ago, so thank you for representing King County. in
Thank
such a
you. It
manner.
was
Thank you.
very exciting going down there. And then I got a tour of the studio, which was fantastic.
Okay, so we have a couple resolutions. Go ahead and introduce your first one.
So the first resolution is a resolution accepting grant funds that we have with the state of Illinois. Again, this is, and I'm just making sure that I'm looking at the right one. This is through the American Rescue Plan. This is money that what we're hoping to do is to outfit a portion of the circuit clerk's office that Ms. Barrero has graciously allowed for our pre-arrest diversion individuals to have. And so then it would not be county money that's being spent to create new office space, since we are desperately out of office space at this point.
Okay, may I have a motion and a second to discuss and potentially approve?
Leonard moves.
Mr. Leonard moves.
Have a second.
Mr. Davis seconds. Any comments or questions regarding this resolution? Okay, may I please have roll call?
Brown,
Brown, yes.
Gums,
Gums, yes.
Leonard,
Leonard, yes.
Sanchez,
Sanchez, yes.
Davis,
Davis, yes.
Molina.
Molina, yes. Okay, and this passes on to our finance. Good with your
Shepro,
second?
yes.
Okay, we got you, Mr. Shepro. Okay.
Okay.
Ms. Musser, go ahead with your next one.
Thank you. Our second resolution is actually a budget adjustment. I think it's being put up there now. It is an adjustment to allow kind of moving funds around so that we can, some funds that are over in terms of certain revenue, but under other places, just putting them together so that we even out at the end.
Okay, may I have a motion and a second to discuss and potentially approve?
Leonard moves.
Brown will second.
Okay, Mr. Leonard moves, Mr. Brown seconds. Any comments or questions? I guess I just had one.
Oh,
Question
actually,
on
can I did say that incorrectly. We had sub-departments in our general fund, and instead of having sub-departments, we're just going to put them all in the general fund. So it's taking all of those sub-departments and putting them in the general fund.
Okay, so that was my question. So these are all sub-departments that are, so is the balance on these sub-departments? I know Mr. Hunt is online in case he has a question. Is the balance then 0 on these sub-departments?
Yes,
Okay.
correct. And so I had done this really early on because I thought it made more sense where, for example, when we created the new positions for abuse and neglect, then we did an abuse and neglect sub-department. But when it went through everything, because we had higher quality people eventually put in, we were taking money from the general fund to put in there. It didn't make any sense. So thankfully, under the tutelage of Mr. Hunt, we are cleaning this up to make it a little less confusing.
Okay. Any comments or questions? Okay, may I please have roll call?
Brown,
Brown, yes.
Gums,
Gums, yes.
Leonard,
Leonard, yes.
Sanchez,
Sanchez, yes.
Shepro,
Shepro, yes.
Davis,
Davis, yes.
Molina.
Molina, yes. Okay, and this passes on to our finance committee. Okay, and go ahead with your third one.
Thank you. Our third resolution again is accepting some additional funds through IDHS for our pre-arrest diversion program to continue to help with the battle against the opiate issue that we have. As I promised when I was elected, we are working really hard to make sure we bring in as many grants as possible to supplement our programs and to help the people. And this is another example of that.
Okay, may I have a motion and a second to discuss and potentially approve? Mr. Davis
Davis
moves.
moves.
Mr. Brown seconds. Okay, any other comments or questions regarding this resolution? Okay, may I please have roll call?
Brown,
Brown, yes.
Gums,
Gums, yes.
Leonard,
Leonard, yes.
Sanchez,
Sanchez, yes.
Shepro,
Shepro, yes.
Davis,
Davis, yes.
Molina.
Molina, yes. Okay, so this passes on and will be discussed at Finance Committee next. Okay, any other comments or questions for Ms. Mosser? Okay, yeah, keep us updated. I know our legislative committee meeting is going to be next week, but I don't know how fast legislation moves in Springfield or possible legislation. They'll just keep us in the loop to see what you need help with.
I will. It looks like if we're able to come to an agreement about a third trailer bill, then it would come during the veto session, which is in the middle of November. I think both Sheriff Hayne and I have a plan to even go down to Springfield to kind of help move this along if possible. If it is then passed with the supermajority, then it could be signed immediately after and effective for January 1st. But I will let you know once we keep going with this.
Okay, thank you for your help. Okay, we will move on our agenda to our public defender.
Good morning. Our reports are on file. Just a couple of things, excuse me, from our office. I know Judge Hull will talk about this, but we worked this week as part of our Safety Act committee in the courthouse in our judicial partners working on creating our protocol for the courthouse, which also leads then to training within our office. And as Sheriff Hayne has pointed out, we also are grateful to Ms. Mosser and her work, although we don't agree with all of the changes that are coming. There are many things in this law that need to be fleshed out and put in better terms so that it will be helpful to all of us who work in the court system. So we are also grateful for the work that she is putting into this. I know she is very busy with this and putting a lot of her time in it. So hopefully there will be some good changes come out. And even though those changes may not come till the end of November or December, we are moving towards training in our office to get prepared. We currently are still in the hiring process. We are currently down 4 attorneys. So our posting is still listed and we are still looking for applicants. And then finally, just to thank our strategic planning committee that has worked all this year. Our office is very excited about the Halloween party that is happening later this month for the county. And to Ms. Barrerio, who I understand that was all her idea. We are looking forward to doing that as part of our legal community and our King County community. So I know that Cecily Carlin, who is the representative from our office, has been working very hard on it. So I hope a lot of county employees will bring their children and it'll be a big success and an annual event. And that's all I have.
Thank you, Ms. Conan. Any comments or questions for our public defender? Okay, so we will move on to our judiciary and courts. Good morning, Judge Hull.
Good morning. First, I would like to apologize for none of us being there. I have COVID, so I am on a 5-day quarantine, and Doug and Andrea are down at a conference. So my apologies for not being there in person. Couple things to put on your calendar. Number one is we're going to be hosting an open house over at the JJC to introduce the public and all of you to the second courtroom that you funded and approved. So that's going to be October 25th from 3 to 4:30. So we would love it if any of you would have an opportunity to come by and take a look. We're very, very proud of the courtroom, and I know you will be too. So we hope to see you. And if that date doesn't work, you can always call and we'd be happy to take you on a tour. Second, some big news. As we told you, Doug Naughton is going to be retiring. November 4th is the final day. Because of the importance of that position, we contracted with the National Center for State Court and did a nationwide search for the new TCA position. After going through an extensive hiring process, we made a decision and we offered the job to our own Deputy Trial Court Administrator, Andrea O'Brien. So we're very, very excited. And And ultimately, a question that was asked, which is a fair question, was if you were going to hire Andrea, why did you have to go through the National Center for the State Court? But what we wanted to do is we wanted to, number one, make sure that we placed a great deal of importance on how we hired that position. Second, we wanted to make sure that we got the best candidate. And so that's why we went and did a nationwide search. Our two finalists were Andrea and a gentleman from Michigan. And at the end of the day, Andrea was by far, she set herself apart, not only with the experience that she has in Kane County, but with all the forward thinking and ideas that she has. So we were very excited to be able to offer her that position. She starts on November 7th. And now we're in the process of backfilling her position. So does anybody have any questions about that at all?
Any questions? No, thank
Fantastic.
you.
Well, I'm looking forward to introducing her at our next meeting as our new TCA. And we are having a going away party for Doug. And that'll be on November 2nd. Doug, as you know, shies away from any sort of recognition at all. In fact, he does not want to have himself recognized for the years of service. He did agree, though, he loves pie. And he did agree that we could have a reception in his honor on November 2nd, as long as we have pie there. So we're gonna have a reception for him, and we will make sure that you get notice on that as well. Next up, as Rochelle just commented, but we've talked about it, and I want to again congratulate Chairman Molina for her leadership on the strategic planning process. We have mentioned it, but we did hire and receive grant funding for a national consultant to come in. We had over 30 members meeting for over 6 months to identify the priorities for that group as it related to our judicial public safety partners. We've identified 8 initiatives that we want to tackle, and one of those 8 was employee retention and just how do we make employees of Kane County feel more welcome? How do we address the needs that they have? And I hope Teresa does talk about it, but one of the initiatives is this countywide Halloween party, which may seem very small in some fashion, but I look at it as a huge step because, again, it's bringing all of us together. It's something that will be important for our young employees to be able to bring their kids. And I think it's just one example of some great things we're going to see over the next year. So to Teresa and that committee, I'm so thankful for that. And then a couple other things, just again, to address what both, well, we've all talked about it, but the Safety Act, as Ms. Cohn had identified, we had our out-of-state consultants here all day with us on Tuesday and Wednesday. We locked ourselves in a room, and the goal of that was to put all the work that we've done in the last 6 or 7 months together to draft an implementation plan. One of the questions I've gotten from time to time is, why was Kane County picked as a pilot site, and what benefits does Kane County receive as part of being a pilot site? Well, the reason why Kane County was selected is, again, because we have a reputation of being innovative and being leaders. And so that was one of the reasons that they reached out and asked if we would be willing to participate. And I enthusiastically said that we would, for the reasons that I just stated. But the benefits, and I think State's Attorney Master and Ms. Conant and the sheriff would echo this, and Teresa, would be that ultimately as a pilot site, what we did is we've been tearing this thing apart, kind of going through, trying to figure out how to implement it, identifying the issues, identifying the problems, identifying the good things about it. And as a result, all that information has been information that State's Attorney Master, the Sheriff Hain, and everybody else has had. And so I would like to think, as State's Attorney Master is engaged in these different conversations, that a lot of the different ideas that have come up, or the issues that have been identified through not only the State's Attorneys Association and the PD's Association, but right here in Kane County, because we're sharing that information not only with other judicial branches, but also with all the other departments. And so we too are very encouraged by the comments about a potential trailer bill. But again, our goal has and always will be that we have to be ready to go on January 1st. And I feel like we've made some large strides getting there. So that would be the report. And if anybody has any questions, I'd be happy to answer on any of the subjects I've talked about.
Thank you. Any questions for our Chief Judge? Okay, thank you. I hope you get well soon. You sound great.
Thank you.
Okay, we will move on to our court services. Mr. Davis, good morning.
Good morning. Our financial reports are on file. We have a brief presentation on pretrial services today, and I also have a resolution for a medical contract at the Juvenile Justice Center. So whatever order you'd like to go in.
Okay, yeah, let's do the presentation first.
Okay, I'd like to introduce Kyle Grenfeld. He is a deputy director in our probation department that works very closely with the pretrial division. He's going to give you a brief presentation and answer any questions you might have.
Okay, welcome. Good morning.
Good morning. Thank you. So some of what I'm going to talk about will be a continuation of what I spoke about briefly back in July. So if you remember, I was here supporting one of our officers who was being recognized for National Probation Officer Week. Judge Hall pulled me up and asked me to speak to some of our pretrial numbers. So some of what I will be saying will kind of be a repeat and continuation of that. Court Services maintains quite a bit of information on bond call and all the appearances. We have been sharing all of that with justice managers, our state's attorney's office, Sheriff Ain, as well as the public defender's office, just to help us better prepare for some of these changes that are going to come. That is what we will be sharing with you today, those same reports. So we have just two brief slides here, and this is just going to be a very general overview of the breakdown of appearances based on charge that we've been seeing for the better part of the last 6 months. So one of the big changes is going to be an emphasis placed on charge and what that means for whether or not an individual can be detained pending their case starting January 1st. So we have broken down the total number of appearances that we have seen on brand new charges over roughly the last 6 months into two categories: appearances that could result in pretrial detention and appearances that could not result in pretrial detention. And as you can see, of the roughly 1,469 individuals that have appeared, it's about an even split, 50-50 between those that could be remanded and those that could not be remanded.
And just a question on this. Can someone be charged with both a non-detainable and a detainable offense?
Yes, absolutely. And that
So-
is not uncommon. So
Okay.
if they are changed with even one detainable offense, we would group them in the category of detainable.
Okay. Okay, thank you.
We can further break down those two categories, which is what you see on the next slide. So again, roughly a 50-50 split of the non-detainables. A small chunk of those are cases that we would not even see in what we now know as bond call. These are cases that must be, or charges that must result in a release straight from police custody. These are low-class misdemeanors, Class B, Class C, traffic offenses, things like that. So again, we don't see a heck of a lot of that volume in bond call, but it does happen from time to time. The big chunk of the non-detainable appearances are individuals that could still be brought into court in the morning, but then ultimately they must be released. If they are brought to court, it would simply be for the setting of release conditions, perhaps including pretrial supervision before they are then released that same day back into the community. Of all the appearances that feature at least one charge for which somebody could be detained pending their case, the vast majority of those are domestic violence or a related charge. That is far and away the most common charge that we see tied to appearances in bond call every single day. So roughly 3/4 of those detainable are going to be domestic violence or a related charge, something like violating an order of protection, something like that. The other quarter is resulting from things that are not domestic violence related. Any questions?
I guess one question where it says may come to court, what happens if a non-detainable offense is not, if they do not present to court, what then would happen to that person?
If they don't come to court, then they would be released, probably straight from police custody and given a notice to appear back in court within 3 weeks.
I could address that if you'd like, Chair Molina.
Yes, go ahead, Chief Judge.
So that's what's called a cite and release. When there's somebody that's charged with a non-detainable offense, the police have two different options. One is to cite and release that person at the scene, just like you would with a traffic ticket right now. So the officer would work with the circuit clerk's office to get a court date And that person, just like a traffic ticket, would be given a court date and to appear at a later time, and they would never even be booked and taken down to the station. The cite and release offenses are Class B, Class C, petty offenses. So your lower level cases. Then there's other cases, for instance, if you take a Class 4 drug case, a felony retail theft, those are also non-detainable offenses. On those cases, they could actually be brought to court just to have an initial hearing. And then after that initial hearing, they would be given a date, but never ever taken into custody over after that initial court date. So again, it's a cite and release and what we're calling a court and conditions. And that's what would happen if it's and even I guess the last category would be if there's a detainable offense like a domestic battery, but the state's attorney chooses not to file a petition to detain, then again, that person would appear in court, be given a court date and released. So those are the three different options that the police have.
And under the new law, what's the time period between, say, when a person is stopped by a police officer to when they have to be in front of a judge?
The legislation says that it has to be within 21 days. So no later than 21 days. Again, on some of the different situations where we're talking about the cite and release type of offenses, we're working with the circuit clerk's office to try to get a quick turnaround so that we can get that person in front of a judge as quickly as possible to address anything like conditions that may want to be imposed. Not to consume alcohol, not to consume drugs, to get any testing. But the maximum amount, it would be 21 days.
Okay, thank you. Any other comments or questions? Okay,
Sanchez with a question.
Mr. Sanchez, go ahead.
Thank you, Madam Chair. Underneath the non-detainable offenses, there's been a lot of stuff going around online about what some of those are, and some that sound kind of scary. Can you speak to that at all and kind of outline what are some of potentially the worst non-detainable offenses that we're recognizing and what that means
Yes.
for public safety?
I would be more than happy to do so, but if you saw my WGN, you would have seen that also, Mr. Sanchez.
I have not had a chance to catch up on the news. I apologize.
So, and to try to summarize this in a small way, there are 7 different categories of offenses that can be detainable. The first portion is forcible felonies that are non-probationable. The second are family violence crimes. The third is aggravated stalking. Then there's domestic battery or aggravated domestic battery, certain gun offenses, certain sex offenses. Those are all ones because they're enumerated offenses or because of the specific victim are potentially detainable offenses. Now, there are ones that don't fall in that. There's a 7th category called willful flight. Willful flight is defined as a person's intention to evade or attempt to evade prosecution by concealing oneself. Simple past non-appearance in court is not to be used to show that they're not going to come into court. Now, the problem is that's a very difficult definition. We believe that that's very restrictive on what we're going to be able to prove. I'm sure Sheriff Hain can talk to you about how few times somebody has told him he's never going to come to court or he's found him with a ticket to Bolivia. For this subsection 7, this willful flight, that applies to anything that's a class 3 felony or above. So now we're looking at a lot of different crimes. So a probationable forcible felony includes things like robbery, kidnapping, burglary. Those are cases that I would have to argue that they are a willful flight in order for them to be detained. So let's just take the example of a kidnapping case. Somebody comes and takes another person, kidnapping, takes a child, but intends to stay in King County because they want to fight this, because they believe that what they did was right. I can't hold that person. That person is in willful flight. I am unable to argue that this person is a danger by the facts of their case. Going back to willful flight, you have to look at the class 4 felonies because not a single class 4 felony can be detained if it doesn't fall under one of those other subsections. So the one that I used, Mr. Sanchez, on my WGN appearance was unlawful restraint. Unlawful restraint, if it's a domestic violence crime, can be held, but unlawful restraint cannot. So for example, if I were to unlawfully restrain Teresa Barrera over here, and I maybe do, I may want to go to Bolivia after all of this. I cannot be held because that is a non-detainable offense by the way that this was drafted. Class 4 aggravated DUI. If you cause an accident and you leave the scene of the crime and that accident causes death or great bodily harm, can't hold that person. A disorderly conduct threat to a school, we can't hold that individual. There are many, many others in regards to this that are very concerning because our first goal is always community safety. And if we cannot argue that a person is a danger to the community because of this, then that is why we have been engaging in a lot of negotiations regarding this. Hopefully that answered your question.
Yeah, I think so. Although some of these sound like they would be a person who would be a danger to the community. And so I'm guessing some of the changes that you and the team are working on are addressing these issues and ambiguities.
That's correct. In our negotiations, I think that the sponsors of the House bill didn't intend to keep out these particular offenses. I think it's just ones that we in law enforcement can automatically rattle off because this is our job. They have been very receptive so far in our negotiations to expanding what they're calling the detention net, which is those detainable offenses that we can have. And we brought up these specific ones. I think they were more than willing to put those in. What they're trying to avoid is people sitting in jail for low-level nonviolent offenses. We did a quick study of our jail to see who was in there. I'm sorry, Sheriff Hain, your jail to see who was in there. That's not being done here in King County. We do not have low-level nonviolent offenders who are in our jail. We are doing what we're supposed to be doing and why the purpose of bail is set. So I do believe there are going to be changes that are going to expand that list significantly.
Excellent. Thank you very much.
Question,
also-
Shepro?
Mr. Shepro, go ahead.
Yeah, Madam State's Attorney, you mentioned that aggravated stalking, I think, was a detainable offense. Could you elaborate on what makes stalking elevated from garden variety stalking to aggravated? Does it require some actual use of force against the victim?
No, it's usually because there's a protective order in place, like an order of protection. So they've already been ordered not to. I'd have to look it up again to see if there's more to that. But I know one of the factors is that you have an order of protection in place that would prevent somebody, or a stalking no contact order that would prevent somebody from stalking you, and you continue to do it. Also, if they cause bodily harm to the victim, they confine or restrain the victim, or they violate a restraining order.
Thank you.
Okay, any other comments or questions regarding the
Bates,
presentation?
please. Bates,
Ms.
please.
Bates, go ahead.
Ms. Mosser, so in these cases where you say you cannot detain, can a judge detain?
No, the judge does not have any discretion. The way that this is set up is that for somebody to be detained, the state's attorney's office has to file a petition, and then the judge has to either grant or deny that petition. If I don't file a petition, then there is no authority for the court to do it. But even if I did file the petition, but it is on a non-detainable offense, the judge would have no authority to do so. That is part of our argument, is the judicial discretion has been taken away as a result of this.
Okay, thank you for your very constructive changes to this bill. Thanks.
Well, we're
Quick
trying to make
comment or-
changes. Changes have not been made yet. So let's be specific on that. Right now, no
Suggested.
changes are made.
Suggested changes.
Quick comment or question, Shepro?
Let me just let Judge Hall speak. I think he had
Sure.
his hand up.
No, I think that Ms. Mosser, I think to address again the question from the Conference of Chief Judges perspective, one of the bigger issues with this bill is the elimination of judicial discretion. And Ms. Mosser commented on it, but obviously we come at this from a little bit different avenue in that, again, as she just highlighted, if the state's attorney doesn't file that petition, regardless of what the judge feels, the judge's hands are tied. And so, again, there are a number of different organizations that are trying to trying to lobby and trying to work with the legislature. Again, Ms. Masser and her team have been doing this, but on our side, on the judicial side, that lack of judicial discretion is really troubling, and we're hoping that that's recognized with the trailer bill.
Thank you, Judge. Mr. Shepro?
Yeah, actually, Judge Ho may have answered my point, which is the public, I think a lot of people in the public have focused on this danger to the community finding. But my understanding from what Jamie and Clinda both said is that the judge cannot make a finding of danger to the community on a non-bailable offense.
Correct. So that is part of what we are in arguments about it, because the first thing that we have to look at is if it's one of these enumerated offenses. The second thing that we have to look at is if there's a person that needs to be protected. And it's only until that third state that we actually get into the arguments about this person being in danger and why they should be detained. When holding somebody, in my opinion, we should always look to see whether or not they are a danger to a person or the community. That should be the first standard. And what we're trying to do is make sure that we can continue to look at cases individually and not do a sweeping brush that says this is what we should do on a case.
Mr. Shepro, another, not to get too far into the weeds on this, but another issue is when Ms. Masser talks about non-probationable felonies. There are some like a burglary or others that are probationable, but then become non-probationable when you commit that offense for a second time, or you commit a similar class offense for a second time. And so what's unclear by the statute is when they're talking about non-probationable felonies, is that based upon the offense itself? Or does something that is probationable that becomes non-probationable because of a criminal history, does that fall into that category? And so that's another one of those areas that hasn't been spelled out by the legislature that we're going to have to end up resolving through court rulings, and then probably having those court rulings appealed.
Thank you. Actually, that's a excellent clarification, because I was wondering about what happened when you had a serial offender in any of those categories, and I gather we don't know.
I think right now, at least the last time we talked about this, I think Ms. Conant, Ms. Masser, and I had at least some different thoughts, but that's why we have the court system, correct?
Sure. And we have to remember, behind all of this is all of the people who work for the judiciary and the court systems trying to do all the paperwork and the backlog, and we're pretty much flipping the way things were done. So when we talk about our budget and we talk about the needs that our judicial partners have, this is kind of what we are wanting everybody to pay attention to, is the job has completely changed for a lot of our employees. And that's going to take a lot of training. That's going to take a lot of time to get them to do a completely different job than what they were used to doing today. So thank you all for your discussion and your time. I think we have one resolution, Mr. Davis.
Yes, I have a resolution before you for a contract extension for medical services with Advanced Correctional Healthcare for the Juvenile Justice Center. It's a one-year extension of our 3-year agreement. There is no price increase. It comes out to $437,193.39 annually. Some of you were involved with this committee 3 years ago when I brought this resolution in front of you. When we took it out to bid at that time, there was only one vendor that bid on the job. It's our current vendor, but they came in at over $600,000. I put a lot of time and effort. I'll spare you all the details into looking at other options and getting the price down to $437,000. So I've spoken to all the other superintendents in the state, and all of them that have had to do their medical contracts since COVID have had significant increases. So in my opinion, it makes the most sense for us to take the one-year extension and then reevaluate next year. So I'm asking you to pass the resolution.
Thank you. May I have a motion and a second to discuss and potentially approve this resolution?
Leonard moves.
Mr. Leonard moves, Mr.
Davis
Davis seconds. Okay, thank you for your work on this, Mr. Davis, and Mr. Leonard, go ahead.
Thank you, Madam Chair. I just wanted to make one comment. 3 years ago, when I was on Judicial and Public Safety, and Mr. Davis did all this work and truly got a 3-year guarantee on rate. Not only was it much lower than the prevailing rate, but it maintained that rate for these next 3 years. Considering inflation and everything else, I think we owe a great bit of gratitude to Mr. Davis for what he did here. And I strongly support this resolution.
Absolutely. Any other comments or questions? Okay, may I please have roll call?
Brown,
Brown, yes.
Gums,
Gums, yes.
Leonard,
Leonard, yes.
Sanchez,
Sanchez, yes.
Shepro,
Shepro, yes.
Davis,
Davis, yes.
Molina.
Molina, yes. Okay, and this passes on to our Finance and Budget Committee. Thank you again for being
Thank you.
here. Okay, we will move on to our Circuit Clerk. Ms. Barrero, good morning.
Good morning, everyone. I just would like to say our report's on file, and I do want to mention a couple of things. We held an expungement clinic in 2 clinics in September, and they were extremely successful. We had over 30, sorry, I had the dreaded COVID also. So I'll be coughing for the next probably 3 months. But we had over 30 individuals at each event. And it turned out to be the first event, we had 17 filers. That's folks that are requesting to expunge or seal a case, a file. So there was 77 cases that were requested to expunge or seal on the first day. On the second day, we had 177 cases that were requested to expunge or seal. So that was a huge success. Hopefully, those folks will get those minor offenses taken care of and removed or sealed from the record. And then they'll be able to go on and get jobs, be successful individuals. And then we also are continuing to work with Tyler to get our computer system upgraded on a 2-year increment. We're still working with ITD and Tyler to get those on schedule because that's super important, since we all know when the system doesn't get upgraded in a timely fashion, it's very hard to play catch up. And now with all the Safety Act and the statistics that we're required to give to the state, it's very important that we get our computer, our CMS running correctly. In mentioning that, I would like to say that in our cases filed that is in the report, in our report this month, you'll notice that the percentage of cases filed increased from last year by 233%. It was 11,009 for 21, up to 39,700 new cases filed, yes, for 22. Now, some of those numbers were because we didn't capture the information correctly before. We're getting that all ironed out, but that's also shows an increase in cases, which means more work for staff, which means, like you said, all the work that is involved in the Safety Act and all the forms that are being redone and all the job descriptions that we all have to change around is going to be monumental. And along with the expungements we're seeing, and then they come from the state also, because the cannabis expungements, which the state has only sent us 1 round so far, so we're still waiting for our 2nd round on that. It's a lot for the circuit clerk's office, but they're handling it stoically. But we do need more employees, just like all of the rest of us. And I dread November 1st, when this all goes into effect for us, when we start actually trying to implement some things going forward. So that's all I have. Oh, I did want to mention the Halloween party that everyone's talking about. We are working, I'm on a focus group that is trying to think of ways to keep and bring up morale for employees for Kane County. Since one of the big issues is pay, correct? We don't have the pay. So we're trying to think of other ways like flex time and work from home and tuition benefits, et cetera. So you'll see more things come down the line from our focus group that we are going to be asking of the county board going forward to try and implement for the employees of Kane County. And one is the Halloween party that we're going to try and do annually. And it will be for all employees and their families. So we're very excited about that.
Thank you, Ms. Barrero. Ms. Gums, I see your hand raised.
Thank you very much. Just a quick question, a follow-up, I think last time about the expungement clinics. Was there any more conversation or is it even feasible to do a remote clinic? And the reason I ask that is some people no longer live in the state and to get to one of these is a challenge.
Well, actually, we did put together a PowerPoint that I was contemplating putting on my website, which kind of it breaks down the whole process. It's, excuse me, it makes it simplified. So a person can actually acquire all the forms in that online. So they don't have to go to a expungement clinic to go on the state of Illinois website or on our website and pull up all the forms. But we do have a process that is pretty simple that explains everything that they will need to do going, to apply, because you don't need an attorney or anything. If you have all your cases, you can easily fill out the paperwork. There is a lot of paperwork, but they are state forms, so we can't simplify it any further than what we already have. So we do have a video. We haven't really talked about doing anything virtual, but I guess we could think of that going forward. Our next event we want to have at the circuit clerk's office. I know that it was deterred that a lot of folks do not want to come to like the sheriff's office. We thought about having it at Aurora Police Station in Aurora or in Elgin, because we try to keep them throughout the county. But many folks don't want to go to a judicial facility when they want to get things expunged. It's a threat that they possibly might be arrested. So that's why we've had these in libraries. But our next one we're hoping to have at the circuit clerk's office, because I think we've taught, our message is we're not here to arrest you. We're here to help you clear your record or get your record sealed if it is possible. So we'll think about virtual. That's a good suggestion.
Thank you so much. I appreciate it.
Comment, Shepro.
Mr. Shepro, go ahead.
Hi. Everybody knows that I have a penchant for historical facts, and I came across a report of the circuit clerk for the year 1850. And I can report that the total number of criminal cases that year were 41. And the largest single offense was selling liquor without a license, 15 of the 41. And it does not look like any of them would have been non-bailable offenses in 1850. So things have changed. I'll pass it around later for people's and perhaps Ms. Barrero's entertainment and by the way, I think that included the entire circuit, which was then many additional counties compared to now. So.
Thank you, Mr. Shepro.
That's history.
Any other comments or questions for our circuit clerk? Okay, we will move on our agenda to our coroner. Mr. Russell, good morning.
Good morning. How is everybody?
Alive.
Hello? Okay, good. Well, then my job is done. But our report's on file. I don't have any resolutions, and I don't really have anything else to say.
Okay, any comments or questions for our coroner? Okay, thank you for being here. We'll move on to our old business. Last month, we discussed a couple of changes to our county code regarding, I believe it was just guns being discharged in different areas. And I think Mr. Van Kerkhoff is here to introduce these ordinances.
Sure. Good morning. Mark Van Kerkhoff with the King County Development Department. Don't usually report to this committee, but I'm the staff conduit for the county board to this committee, mainly because these are concerns that have been growing in different districts and in different board members' districts. We brought these as topics of concern last month. As a reminder, it's at this committee because both of these proposed ordinances would be enforced by the sheriff's deputies and either go to a court as a ticket or potentially as an administrative adjudication program, but it would be something that would be enforced by the sheriff and enforcement also assisted by the state's attorney's office. So with that, what you have before you this morning are two different resolutions. First one is amending Chapter 12 of the County Code. This was drafted and recommended for this chapter by the King County State's Attorney. And I do want to especially thank Assistant State's Attorney Don O'Brien for his work. He did a lot of research and has crafted these two resolutions for you this morning. So the first one does have to deal with the discharge of firearms. We can discuss this one first. The second one amends Chapter 15, which is the nuisances and property maintenance under the noise section, dealing with the amplified music and sound. So with that, you have those before you. State's Attorney Don O'Brien is here this morning to answer any of the legal questions because that would be out of my league. Thank you.
Okay, let's start with the first ordinance. May I have a motion and a second to discuss and potentially approve the ordinance amending Chapter 12.
Davis moves.
Mr. Davis
Seconds.
moves, Mr. Leonard seconds.
Question, Shepro?
Mr. Shepro, go ahead.
Could Mr. O'Brien perhaps give us a brief reminder of what this changes or clarifies?
Well, the firearm discharge is to add a nuisance ordinance to the nuisance ordinance, Chapter 15. Presently there is no
Mike, please. Mike, please.
Presently, there is no nuisance ordinance that would cover this. The only present nuisance offense is loud and raucous noise. That has been the ordinance that has been enforced and on the books for many years, and that is what the sheriff has been forced to try and cite people for. There is a criminal offense under the criminal code 5/24-1.5, which is reckless discharge of a firearm. It is very close to what is included in this draft ordinance. What we tried to do was to put together an ordinance that is something that could easily be enforced. It short of being the conduct in the felony offense. It adds a number of exceptions that are included in various, I'm going to say, similar ordinances in various counties and cities in the state of Illinois. We think that this is enough. It is a standalone ordinance that goes into Chapter 22, and it contains its own felonies. Its own offenses. It has an additional a larger fine for repeated offenses. We accepted in there for shooting ranges. We did an exception in there for law enforcement, defense of people or property, and hunting. There is also an exception in there for discharge of a firearm in a theatrical event or at a veterans memorial service. We put in at the very end, we put in a provision which gives the state's attorney's office discretion to charge somebody under the reckless discharge of a firearm offense under the criminal code.
Follow up, Madam Chair.
Mr. Shepherd, go ahead.
Yeah, so as I understand it, this ordinance, with putting aside the exceptions that you've outlined, this would eliminate the need to prove either recklessness or that it caused undue noise, and the mere discharge would itself be a nuisance per se.
Yes, the purpose of this though is it has to be in a within 300 yards of a residential structure, and that's defined as 3 single-family or multifamily residential structures.
But your good work eliminates the need to try to prove that it was noisy after the fact or that there was an element of recklessness in the discharge.
Yes, and the other element is that there's likely to be residents or passerbys that would have risk of injury. So
Thank you.
We're trying to cover the bases. We're trying to come up with with an ordinance that is subject to proof in court if it comes down to that.
Thank you. I would join in Mr. Van Kerkhoff's commendation of your work on this ordinance. Thank you.
Thank you, sir.
All right, Mr. Leonard.
Thank you, Madam Chair. I would also like to thank you for your work. In very basic terms, it looks to me like this ordinance is defining the fines that can be applicable by the Sheriff's Department and or the State's Attorney's Office. Is that correct?
That's well, the fine, this would be the sheriff would cite the offender with a citation. And the citation would then be returnable in the Kane Branch Court. And they would come in and a judge presides in the Kane Branch Court. And it would be treated as a quasi-criminal ordinance violation, like all other ordinance violations today.
First offense 250, second 500, third 750. And then I saw an additional $115 fine that could be charged to by the State's Attorney's Office. Is that correct?
No.
It's in the bottom portion of C.
We don't, it just said it gives what the maximum fine would be, but we don't assess fines, neither does the sheriff's office. That's the province of the judiciary over there.
Thank you.
When you
very
go
much.
over to prove up one of these cases, you ask the court to assess the fine in a certain amount. What we wanted to do is put some teeth in this over and above what a normal ordinance violation case might be.
Thank you.
Okay, any other comments or questions regarding this ordinance? Sheriff Hayne, I know you participated a little bit in this. How do you think this sits? Like, is this something that you think will work, or I guess I'd like your
Absolutely.
opinion.
And again, I commend the work of Mr. O'Brien, and I like all the nuances that were considered here. And I was glad that we discussed this publicly. After our last open conversation in judicial public safety, a few sporting clubs reached out to me in deep concern that we were trying to shut them down. So I didn't even think at the time to include that in discussions with Mr. Van Kerkhoff. So we were able to get that added in just to make sure they're protected. And I think that this considers all sides, and it considers the growth of Kane County. And you know, we can't just be shooting randomly in neighborhoods anymore in areas that used to be farmland.
Thank you, Sheriff Hayne. Okay, any other comments or questions? Okay, may I please have roll call?
Brown,
Brown, yes.
Gums,
Gums, yes.
Leonard,
Leonard, yes.
Sanchez,
Sanchez, yes.
Shepro,
Shepro, yes.
Davis,
Davis, yes.
Molina.
Molina, yes. Okay, and this ordinance passes and it'll be discussed next at executive. It doesn't have to go through county development? No, okay. Okay, so let's go ahead and introduce our second ordinance amending chapter 15. May I have a motion and a second to discuss and potentially approve this?
Brown moves.
Mr. Brown moves,
Leonard
Mr.
seconds.
Leonard seconds.
Right.
Okay, we can have an introduction on this one.
Thank you, ma'am. This is an effort to add a nuisance ordinance for amplified sound and music. Presently, there is, again, the only nuisance ordinance is for loud and raucous noise. This has been what the sheriff has had to enforce in the past. There are two other amplified music provisions in the Kane County Code. One of those is in the liquor ordinance, which prohibits amplified music, but that is only on the premises of a licensee. There is also an amplified music provision in the special events permit, where Mr. Van Kerkhoff's office would issue someone a permit to hold a special event on some property, such as a festival. And there are limits on the use of amplified music. We have been faced with a number of I'm going to say, instances in the past couple of years where there are farms that are being purchased, the barns are being renovated to become music and wedding venues. These are usually unpermitted. They do not have an occupancy license. They do not have a liquor license. They do not have a license from the health department, but they go ahead and hold events. Frequently there is outside music where bands come in and they play all day and they play all night. This is an effort to add an amplified music nuisance ordinance. It is a combination of what is in the liquor license ordinance, and it is a combination of what is in the special events permit. It defines what amplified music is, and it sets hours when you may not have amplified music. Obviously, the focus of this needs to be on areas that are near residential areas. Zoning is such that you may have a place that is not residentially zoned, but it is adjacent to residential areas, and the neighbors hear this music and they complain to the sheriff's office, who then has to go out and issue a citation. So we wanted a nuisance ordinance that defines amplified music very broadly to include live music. It could be recorded music. It could be a radio broadcast. The way you measure it, of course, is 75 feet. This is the same distance that is used in the other two ordinances that I mentioned. We set hours, which are Sunday through Thursday, and then Friday and Saturday, or before a holiday. Again, this is an effort to try and put together a very well-defined ordinance that the sheriff's deputies can use to go and cite people where there is this loud music coming from a property. We think 75 feet is something that's easily ascertainable by a deputy out there. We did not, there are statutes that require setting decibels. We did not want to go into the decibel business and have a deputy to have to carry around a meter with him. And then you have the problem of, is the meter been properly set up and calibrated and things like that. So we think that this is again, a tight nuisance ordinance that it can be used to cite people, and it can be proved in court.
Okay, any comments or questions? Mr. Leonard?
Thank you, Madam Chair. Just one question. I like the ordinance. I think it's great. I'm just wondering out of curiosity, if there is a citation issued for a violation of this ordinance, what could the potential penalty be for violating this ordinance?
It goes into the ordinance code. It would be the same as every other ordinance. You can end up if you do this repeatedly, it ends up being a maximum of $500. And under the nuisance ordinance, each week that you do this is a separate offense. Right now, the loud and raucous noise violation we have in the present nuisance statute is not good enough. We think when we're faced with situations like I've talked about, where we have these party barns and places that have loud amplified music that play all day and all night.
Mr. Brown, did you have a question?
I do, thank you. I think it's good to get this ordinance out here, although I do have a question, and I'm sure it's me that I just don't understand this item number 1 and 2 under paragraph C. I've got a case in my area that I represent where the Batavia Moose has different events throughout the year, a couple, maybe 2 to 4 events, and they're special events, and they get a permit to conduct these, and they have outside amplified music. They're surrounded by residential, although they are in the county, but they are surrounded by residential. And over the years, they've never had a complaint that we've been able to find that any of the neighbors have complained of the music. It came to my attention this last year when they got their special event permit that the event permit required them to stop the amplified music at 9 o'clock. They've always gone until 10 o'clock prior to this, but this last year it was found that the ordinance said 9 o'clock, so that's how it was submitted and approved. They asked if they could go until 10 o'clock. So I called Mr. Van Kerkhoff, and he was, I gotta tell you, I can't tell you how much I appreciate how fast this county works, because it was at 8:30 in the morning that I got the email from the Moose asking me if I could look into this. And by 11:30 in the morning, Mr. Van Kerkhoff worked with myself and Madam Chair, and they were able to get a variance to work until 10, or to have this amplified music until 10 o'clock at night. So they were very appreciative. They are huge fundraisers for the Moose and what the Moose charities do. And I guess I'm asking, I don't understand whether the way this is written, whether they'd be able to operate until 10 o'clock or is it 9 o'clock?
Sure.
So the difference here in what this ordinance closes in terms of a loophole in the ordinances we already have in place for addressing sound is right now the only restrictive measures on hours for sound is for establishments that have a liquor license, or for locations or individuals who apply for and are issued a special event permit. So with that special event permit, they have the same hours of operations are standard in that. So this new ordinance mirrors what's in our special event permit application and standards. But under that special event permit, they can apply for a variance to go later hours, which is what the Moose made use of. We often get people apply for a variance, and we work with Madam Chairman on recommendations whether or not that's a suitable request based on the geography and the history with the property for that special event permit. So that system seems to be working fine. The loophole that this ordinance really addresses is that if someone has a private party at their home with less than 100 persons, they are not required to get a special event permit. So those restrictions don't apply. So our deputies respond to noise complaints all the time. One of the things they have to ascertain when they approach the property, if there's any sound restrictions, are do they have a special event permit? And if they don't, that's a potential violation there, but they have to try to figure out how many people are on the premises. If they ascertain that there's more than 100, which is often the case in some of the situations that Mr. O'Brien mentioned, then they would also let us know. We could copy the report and we could follow up and cite them for a violation of not getting a special event permit. But if it's less than 100 people, there's really no control. There's no action the deputy can do other than to appeal to the goodwill of the people to turn the music down out of courtesy. A lot of times that doesn't happen, or they do and they turn it right back up as soon as the deputy is, 5 minutes away. I know there's instances where deputies have returned to a site 3 or 4 times. So this would give them the ability at the first site time to issue them a warning or give them a citation if it's a repeat thing for any size of event, whether it's less than 100 persons. And that's the only issue on the property is the amplified sound or music. In which case they would not have a way for a variance, but under a special event permit, they could apply for that and get a variance. I hope that answers your question, but
Well,
the moose is still safe. Let me put that way.
It looks like there's language in there that.
Question for Mr. Van Kerkhoff, Shepro.
1 second, Mr. Shepro. Mr. Brown had a follow-up
Madam
question.
Chair, so in the case of the Moose, then, when they apply for their special event permit, do they need to require a variance at that time if they want to go to 10, or is it?
Yeah,
permissible?
there's a place on the application form to request a variance.
Okay, very
And then
good. Just so I'm clear.
Sure,
Thank you.
absolutely.
Okay, Mr. Shepro, go ahead.
Yeah, I just wanted to, I think, confirm is when the term variance is used, it's not a variance like a zoning variance to, use a lot that requires public hearings and notice and all that. I believe, Mark, that is a administrative variance that you as the zoning officer can grant. So that's why it was able to be addressed so quickly in the instance that Mr. Brown just pointed out.
Yeah, it is an administrative variance. Our special event permit ordinance is written for the authorities with the county board chair. So it's actually the county board chair who has the authority to administer that. But we work as a team, my department, health department, the sheriff's office, when we review special event permits, when we bring those to the county board office for approval. If there's a variance requested, we have a recommendation whether that's appropriate or not based on the history and specifics of the property.
I guess the point is that is not an onerous or time-consuming procedure for an applicant to do that, which is why I think this issue has been wrestled with by the county board. I remember 10 or 15 years ago when I was the attorney, and all of the things that were mentioned, having to lug decibel meters around, the deputy showing up and not really having anything that they could do other than say, can you turn it down? This is a worthy companion to the first ordinance that, as everybody has said, closes loopholes and eliminates the need for decibel-related technical enforcement. So I again commend the solution to what seemed to be a endless problem over the years.
Okay, thank you. Any other comments or questions, Mr. Brown?
Just to follow up, because I just had to explain what happened with the moose situation, I publicly want to just thank Mark and his team and Madam Chair for working with me on that morning of great concern to the Moose Lodge, and the comments I got back from them were, if this is the way county works, I'm sure glad we're in Kane County. And this is the way the county works. So they were very happy that they got the variance. It was a successful event for them. And they plan on conducting them again next year too. So it's a great fundraiser for them.
Thank you, Mr. Brown. Any other comments or questions related to this ordinance change? Okay, may I please have roll call?
Brown,
Brown, yes.
Gums,
Gums, yes.
Leonard,
Leonard, yes.
Sanchez,
Sanchez, yes.
Shepro,
Shepro, yes.
Davis,
Davis, yes.
Molina.
Molina, yes. Okay, so this passes on and
Is
will
it,
be.
is it just, is it
discussed.
implied in there that there's a certain leniency for classic rock and roll as opposed to something like contemporary jazz?
Oh,
You know,
jazz is.
Lower
can-
tolerance there.
You can bring up any changes
Sure.
at our
That- that
executive
would-
committee, Mr. Davis, if you wanted to amend it. Okay, thank you, everybody. Thank you, Mr. Van Kerkhoff, for your time and your effort on this. Really appreciate it. Okay, so we will move on. I don't have any new business to discuss. Does the committee have anything new? All right, hearing and seeing none. May I have consent to place written reports on file?
Yes.
Unanimous consent, yes.
Okay, and there is no need for executive session. May I have a motion and a second to adjourn?
On behalf of Mr. Kenyon, I move to adjourn.
Shepro seconds.
Okay, motion made by Mr. Davis, second by Mr. Shepro. All right,
They
any,
ran over too.
all those in favor?
Aye.
All those
Aye.
opposed? All right, thank you, everybody.